Please be seated.
We now take up the final case on the docket today, Sanchez-Torres versus the state of Florida.
Good morning, Your Honor. My name is Robert Berry, along with Colon Reddy. We're representing Hector Sanchez-Torres before this court. This is an appeal of a denial of 3851 relief and also a simultaneously filed habeas corpus petition. And it's that habeas corpus petition, and in particular, what I write up as issue 1 in my brief, the issue of whether the grand jury has to find elements of the offense is the issue I want to argue today. The U.S. Supreme Court in Hearst found that aggravators are elements. This court on remand in Hearst said aggravators are elements. Even Chief Justice Kennedy in dissent said aggravators are elements. And so we get to an issue, I think, pretty quickly. And from an earlier argument a couple of weeks ago, Justice Luck asked one of the litigants whether or not Foster controls. And I have to say that there's some confusion in my mind, at least mine, maybe nobody else's, about what Foster is really doing.
Did we clarify whatever that is in Rogers? Because I think I asked that question before Rogers came out.
Right. I think that's right, just sequentially. I hope you did, because I think it helps my case a lot.
Okay. Tell me why.
As I read Rogers, and the last time I checked it wasn't final, but I'm going to assume for purposes of our argument today that it is likely to be final.
It's certainly our precedent right now.
It is your precedent right now. What I think the court is saying is, in keeping with Hearst, the binary question of the existence of an aggravator, whether child under 12 or law enforcement officer or heinous, atrocious, and cruel, that binary question is something that is an element. What I think the court has done in Rogers and Rivera, I think is the middle one, and Rogers most recently, is retreating, and I think appropriately so, from its position out of the remand on Hearst that says, how much weight do you assign to an aggravator, the balancing of aggravators versus mitigators, and that the court is receding from the position that those are elements, because those are sort of amorphous questions.
So, counsel, I think your reading is probably right, and let's stipulate that an element that must be proved in order to sentence someone to death is that there is an aggravator out there.
Yes.
The question is, does that have to be alleged by the grand jury, which returns the indictment? And where we have case law which has said that it is sufficient alone to put someone on notice of the charges against them to allege the statute for which they are charged and generally indicate the crime in order burglary in violation of this particular section and statute, that's sufficient. Why would it not be sufficient to state someone is sentenced to premeditated death, which we know is death eligible, and here's the statute, and the statute indicates that there are 7 and only 7, there may be more, I'm guessing, 7 or only 7 aggravating factors which could make one eligible for death. Why is that not enough?
Because I think what the flow in the state's thinking, and with all due respect, I think it's reflected somewhat in your question, is notice the raison d'etre of grand juries, and it's not. The history of the grand jury does not suggest anywhere, from an originalist standpoint, it's pretty easy stuff. The grand jury has always found what Blackstone referred to as simply the accusations, what Judge Hurd in the treatise I cited recently in my supplemental authority book down the hallway here said are, interestingly enough, aggravators, which have to be pled. Our Rule of Procedure 3.140 says you have to allege essential facts, which are, I don't know how you get around the idea that an aggravator isn't an essential fact. And then we turn to what the U.S. Supreme Court is calling elements, which is sort of a new...
If there is a deficiency in the indictment or information, do we have a rule of criminal procedure which requires that be brought to the attention of the parties before trial starts or during the course of the proceedings.
In certain instances, 3.190 does that.
Right.
Not in this instance.
Why is
Not
that?
in a fundamental problem like this.
Well, let me ask you this. Was this brought to the attention of anybody during the course of the
Oh,
proceedings?
absolutely not. I'm not
So-
going to argue that.
So it's fundamental error? Well, we'd review
Fundamental
it.
or structural, whatever you want to call it.
Okay.
But again,
Counsel, those are very different things, and we know those are very different things. So let's go through them one by one.
Okay.
Would we review it under our fundamental error standard?
I'm going to frustrate you a little bit by
You're not frustrating me.
by answering another question sort of first. My view is the Gray case is the door that unlocks my ability to litigate this issue because of the failure to allege an essential element of the offense in the charging document.
Well,
Now-
would we review it under our case law under fundamental error is my question.
Let's assume that Gray is a fundamental error case.
Okay, haven't we said that, whether we're right or wrong, that where there's a fundamental error, that it is not ineffective assistance of appellate counsel to allege, or appellate counsel is not ineffective for failing to allege that fundamental error?
And again, I never want to frustrate anybody.
You're not.
But let me tell you the position I was in as the inheritor of this case from an attorney who wasn't qualified to handle this case at the circuit court level. I asked for a remand. This court denied that remand. I couldn't then plead an ineffective assistance of trial counsel, which may have been the better, if I had handled it from the beginning, I probably would have handled it through that vehicle.
So I think you might still run into the fundamental error
I think so.
wall, even if it wasn't ineffective assistance of trial counsel as opposed to appellate counsel claim. But let's get beyond that for a second. You mentioned structural error. Has any court in Florida or the United States Supreme Court or any U.S. Circuit Court of Appeal ever held that a failure to allege an essential element in a grand jury indictment is a structural error?
A grand jury indictment?
Yes.
Nope.
Right. So it's not structural error. We can, at least, no one's ever said it is.
No, I don't concede that, Your Honor.
Okay.
The fact that it hasn't been erased, I mean, for example, you know from your work as a federal prosecutor, I may be presuming something. I don't know if you handle death cases as a federal prosecutor.
I did not.
But I imagine you're aware from the DOJ guidelines that you submit all of those aggravators with the exception of one, to the grand jury in any case where the United States government is seeking to. And that was an immediate and direct result of Ring Apprendi coming out. They immediately adjusted their procedures, so there wasn't any federal basis to make that argument.
Well,
because it was taken care of through.
The question isn't should or shouldn't as a matter of policy, and it's not even should or shouldn't as a matter of error. It is it ineffective for an appellate attorney in reviewing this record to have failed to have brought this up in the direct appeal? And
my position is yes, because when you look at, but for the failure to allege, let's assume just for fun that I'm right and that grand juries do have to find aggravators in a charging document, just like they have to find aggravators beyond a reasonable doubt in the
well, let me
trial
ask this before you get there. Is
Sure.
the citation to the statute in the grand jury sufficient to allege that all 7 aggravators are present in the case? Or 9
No, because the
that are
aggravators
statutory?
are outlined. Actually, I'm rethinking my answer. I think there's A through P, so whatever that is, 16
Okay,
aggravators are listed in the statute.
right. So is the reference to the statute,
It doesn't reference that statute. It references
The grand jury statute doesn't-
780.
wait, I just want to be clear, the grand jury indictment in this case did not reference the death penalty statute?
775-087, 775-087 sub 3, 782A4, which is the murder statute. It doesn't get into the aggravator statute. It doesn't list 921. So the answer to your question is no, it doesn't list that.
Okay.
Let me ask you a question about this argument. I'm going to quote from Hall versus State, which says that this court has repeatedly rejected the argument that aggravating circumstances must be alleged in the indictment. That's quoting also Pham from 2011. and then goes on to say, nothing in Hurst indicates that our holding impacted this settled point of law. And we've also held prior to Hurst that neither Apprendi nor Ring requires that aggravating circumstances be charged in an indictment. That's quoting Rogers from 2007. Is that the issue of law that you're arguing, the one that's well settled in Florida?
I don't know how it's well settled in the aftermath of Hurst, which clarifies.
Well, I mean, I'm
frankly,
quoting from Hall, which is
It's post-Hurst.
I'm quoting from Hall, which is post-Hurst. And
It may be settled because of a list of cases that preceded it, but I don't know where, I have no idea whether the litigants in that case argued to the extent that I am the history of the grand jury clause. Again, if you look at, I don't know how you reconcile any holding to the contrary with the history of the grand jury clause throughout our history. Judge Hurd mentions aggravators specifically in his treatise from 1868. And if we're all, as Justice Kagan said, originalists now, then in any originalist analysis of the grand jury clause as it applies to this situation clearly demands that aggravators be charged because that's what the common law required. So you can, I cited a bunch of cases, and I think I added one that I left out of a string cite, the Miller case, where the court has held the opposite of what I said. My point is, you can't reconcile that from an originalist standpoint with the grand jury history in our state, much less the more broad grand jury history, which there is no daylight between the two.
Well, but I don't know about it from an originalist perspective. I mean, the whole concept of the aggravators is sort of an Eighth Amendment creation that itself kind of rejected the common law baseline of certain crimes leading automatically to death, et cetera, et cetera. So I don't know that phrasing it in originalist terms really helps us understand this. I mean, I understand that sort of by analogy, the Supreme Court has referred to these as elements and have required them to be found, proven beyond a reasonable doubt and found by the jury, et cetera. But I don't know that that has been looped back to treating them on the front end as the same as what is traditionally understood as the elements of the actual offense.
Well, Justice Mooney's, under the common law, I mean, there was a definition of first-degree murder and felony murder, and it probably mirrors pretty much the basis of 782.04 in our current statute. But if I understand originalist principles, and I don't claim to be an expert on this, but I've read a lot about it, the process is, if you went back to those people, the founders, and said, here's what we're going to do. We're going to take the basic definition of common law murder, but we in a more enlightened society say we're going to segregate out what specific elements, we're going to make it
no,
harder
but the
to
founders
prove.
wouldn't have had, the founders, the aggravator requirement is a post-founding invention.
Well, and that's why that's why I cited Judge Hurd's treatise, where he uses the word aggravators and said the failure to allege them leaves the state with only the ability to prove the charge that reflects the elements that are included in the charging document, and the government fails to allege those at their risk, at their peril. They lose the ability to prosecute more serious offenses.
But counsel, at the founding, we had very stringent pleading requirements, including those of preservation. And really, that's the wall that you're up against here. Even assuming I agreed with everything that you said about it ab initio, none of what you said affects that we have these established rules of preservation that really seem to preclude the claim, right?
Not under Gray. The door is open through Gray. I mean, and either I could be reading it wrong. Don't think I am, but you all will tell me. But when you talk about another thing you have to look at when you look at what do the founders talk about, this isn't something that just existed as to our original Constitution. It was in the 1838 Constitution, in the 1861, in the 1865, in 1868, in 1885, as recently as 1968. So this is a line of thought that doesn't just tie to, people that have been dead for 200 years. I watched your Senate testimony. It ties to people much more recent than that, but does reflect a history that precedes, any of the people that are in this room ever walking the face of the earth. Judge Hurd using that phrase aggravators.
But required a contemporaneous objection if there was an error, so that it could be corrected, right?
You're talking about as of that time period?
As of any time in the history of jurisprudence.
Well, Gray says no. Gray says you can do it by habeas corpus. You can raise that at any time. And that's what it says.
There's no case in between that said something different than that?
I jeopardized Gray. I saw a 5th District decision but it was a different set of facts. It really wasn't probative of this particular issue. Your smile suggests that there's something that I'm missing. Wouldn't be the first time, but Gray is a Florida Supreme Court decision. It has never receded from Gray unless Shepard's is a really lousy system of legal research.
Counsel,
Am I at the 16?
yeah, you're approaching your rebuttal, so I think you're now in.
And now I'm there. Thank you, Judge.
Chief Justice Kennedy, Justices of the Court, may it please the Court. My name is Jennifer Donahue. I'm an Assistant Attorney General, and I represent the state in this matter. This court should affirm the post-conviction court's denial of all claims in this case and deny the habeas petition. Now, this is certainly an interesting intellectual conversation exercise about whether the aggravators should be included in the indictment, but here, the aggravator of the contemporaneous felony of robbery was included in the indictment. So this isn't even really an issue in this case, not to mention that it wasn't preserved at any point, which Gray may say that you can wait, but we have a system of requiring contemporaneous objections for a reason. That's so that the defendant doesn't wait until we get into post-conviction and then raises an issue that now we should go all the way back to the indictment in this case. It's almost akin to an invited error issue. So certainly, if there was an error, which there isn't in this case because it was included in the indictment, it would be a fundamental error standard which was not met here. Additionally, the grand jury requirement is premised a lot on notice. And in this case, the defendant was given notice of the intent to seek the death penalty based on 4 aggravating circumstances, and he was given that notice on 8/30/2010, which was almost 8 months before he took a plea in this case. Certainly, as far as fundamental error is concerned, we don't find ineffective assistance of appellate counsel for failing to raise every single conceivable issue. And when fundamental error is the standard that we're looking at to overcome, certainly appellate counsel in a direct appeal is not ineffective for raising something that doesn't amount to fundamental error. Mr. Berry suggests in his brief that adding an aggravating circumstance in the indictment and requiring the grand jury to discuss that aggravating circumstances would get our opinion of the consciousness of the community on whether this should be a death penalty case or not. But the grand jury process is not adversarial. The defendant is not there presenting mitigating factors for the grand jury to weigh. So really the consciousness of the community is not even at play. All the state would have to do in this intellectual exercise is present one aggravating circumstance, which is required in order to make it the defendant eligible for the death penalty, which was done in this case with the robbery, and have the grand jury decide whether there's probable cause to believe that that one aggravating circumstance had been met by the evidence presented at the grand jury. So as I said, this is certainly an interesting intellectual exercise to determine Hurst's impact on the grand jury, but Hurst changed nothing. The aggravating circumstances are not required in the grand jury indictment, and even if they were required, they were provided here. Pending any questions from this court should affirm the denial of all the claims in this case and deny the state habeas petition.
What have we said about, sorry to interrupt, but what have we said about fundamental error? In other words, error that's not raised at any time in the trial court proceedings, or really ever until the habeas petition, and ineffective assistance of appellate counsel habeas, which is different than a general habeas claim.
That in order to meet the standard of fundamental error, the appellate counsel would have had to overcome, basically demonstrated that error alone vitiated the proceedings, that it affected the proceedings so much that we need to overturn it.
Have we said anything about whether counsel is ineffective for failing to raise a fundamental error?
Right.
What have we
Counsel is
said?
not ineffective for failing to raise a claim that requires meeting the standard of fundamental error. And there are plenty of cases that also talk about counsel's not required to raise every single conceivable potential issue that might have some merit to it, and certainly it's harder to get to that merit level if it's a fundamental error case. And here on direct appeal, the counsel raised the issues that he thought were the strongest issues, and this court rejected those issues. Pending any questions, thank you.
The error here, again, if I'm right, does vitiate half the proceedings.
Can I interrupt you to ask, did you
Sure.
did you cite Gray in your briefing?
Absolutely did.
Okay.
It's in the first page of it, Judge.
Okay.
The state alleged that there is a aggravating factor that was found by the grand jury here.
You and I, Judge, both know that the grand jury was not asked to litigate or deliberate on aggravators. What they're trying to do is concoct some sort of aggravator out of the jury deliberations on. Really, to do it in this case, you'd have to look at count one, for example, and say that the felony murder theory, they allege premeditated, which then the way they drafted this indictment would not include an aggravator. But then the felony murder theory in count one, I guess, would include an aggravator, but it wasn't, they weren't asked to deliberate that because the procedures don't call for it. And so the idea that you can concoct some indictment out
Didn't the
of...
grand jury come back by probable cause that there was, in fact, some underlying crime that would have been eligible as an aggravator?
Not eligible as an aggravator, Judge. What you want to say is that, okay, well, they alleged a count two robbery.
Right.
They're not alleging it, they're not incorporating it in reference into count one as an aggravator to analyze. They did charge a robbery, but you don't,
In the same information on the same date at the same time, right?
but not as an aggravator, Judge.
Right.
I get the idea that to salvage this somehow, you concoct this idea.
Well,
but
I'm not
there's
doing
nothing-
anything, counsel. I'm
I'm
merely asking a
responding to
question.
their argument.
I'm merely asking a question. But my question to you is, what was the basis for finding death here? What were the aggravators that ultimately were found? Wasn't robbery one of the bases?
Robbery was one of them, and a non-alleged aggravator, the prior murder.
Right. And all we need
Which
is
isn't
one. To meet the grand jury requirement, all we need is one, right?
To respond to the pleading, though, my position is that they don't allege the other murder, for example, in this case.
To meet the constitutional requirement that you're talking about, all you would need was one, right?
Yes, to the extent that the fight in the sentencing phase would be about that one that you are ascribing to the grand jury. The other one, the prior murder, no, you don't get to litigate that one because it wasn't pled.
Right, but as to the one, there is one that was pled that the grand jury did find, and that was a basis as an aggravator that the trial court used to impose the sentence here.
And in this case, if I recall the order correctly, the judge focused on the non-alleged aggravator in his decision to sentence my client to death based on the other murder, which isn't alleged in the charging document. So even in that situation, you'd have to remand for a resentencing on the unalleged aggravator.
There were two. There were the prior violent felony and that the murder was done in the course of the robbery.
I'm talking about the indictment, Judge. I'm not talking about the sentencing order.
I know, but he was ultimately sentenced for something that the grand jury did find, was he not?
In part.
Right.
And something that they didn't find.
Okay. Thank you, counsel.
Thank you.
All right, we thank you both for your arguments, and the court will now be adjourned. Thank you.
All rise.